Mr. Speaker, sir, I move that the Finance Bill number 7 of 2020 be read a second time. The bill provides for the implementation of measures announced in the budget speech and its annex and for matters connected, consequential or incidental thereto. The budget, which I presented last month, has introduced a significantly large number of measures, policies and fundamental reforms affecting most sectors of our economy and society. The implementation of many of them requires amendment to existing laws and regulation. Accordingly, this finance bill brings amendment to 70 enactment. Mr. Speaker, sir, I will highlight the main features of the bill. I will start with legislations in the banking and financial services sector. Amendments are made to the Banking Act and the Bank of Mauritius Act, mainly to promote digital banking, develop credit scoring services, and strengthen the supervisory and regulatory powers of the Bank of Mauritius. Thus, Clause 2 amends the Banking Act as follows. In Section 2 and 5, to foster the development of digital banking. Section 14D is repealed to transfer the responsibility for supervision of money lenders from the Bank of Mauritius to the Financial Services Commission. In Section 20, to enable the central bank to vary the capital adequacy ratio to a lower level should the need arise or in exceptional circumstances. Amendments are also made in Section 64 to allow exchange of information with the Credit Scoring Services Agency, and in Section 66 to 69 to vest the conservator with the powers to execute any instrument in the name of the financial institution and to establish a time limit restricting the duration on conservatorship. Clause 3 amends the Bank of Mauritius Act as follows. In Section 2 and 35 to 37, to provide for the definition of digital currency and cater for the issuance of central bank digital currency. In Section 6, to cater for the issue of green bonds and blue bonds. In Section 46, to allow for any amount invested by the central bank in a corporation or company not to be included in the computation of the official foreign reserves of the country. In Section 52(2)(a), a new Section 52(b) to provide for the establishment of a Credit Scoring Services Agency, and in Section 52(a) to enable the BOM to disclose information collected in the Central KYC Registry. Clause 15 amends the Economic and Financial Measures Act in Section 3 to empower the Bank of Mauritius to issue directives in addition to instruction and guidelines. Clause 38 amends the Mauritius Deposit Insurance Scheme Act to allow for investment of the Deposit Insurance Fund to be outsourced to the Bank of Mauritius, to provide for payment of insured deposit by Mauritius Deposit Insurance Company to apply only when the conservatorship has failed and the financial institution is in compulsory liquidation, and to provide for indemnity of employees of the MDIC. As regards financial services, Clause 21 amends the Financial Services Act as follows. To provide for the definition of money lender and peer-to-peer lending and the licensing of money lenders. To empower the FSC to collect information on a conglomerate group, including unregulated entities which would impact on the safety and soundness of the financial group. To provide that the absence of an appointed chief executive, the board may appoint such employee to exercise the power set out under Part 8 relating to powers of the FSC. To provide for prior notice to be given when a licensee wishes to surrender its license, and to provide a time frame to licensees for a proper transfer of business operations to the transferee. To give a flexibility regarding the filing of annual financial statements during a curfew period or situation of emergency or natural disasters. To cater for exemptions for filing of annual financial statements where the FSC is of the opinion that it is not applicable. To provide for the duties of auditors of all licensees of the FSC to include the reporting of irregularities to the FSC, and to provide for the enforcement committee that the enforcement committee shall consist of not more than 4 employees designated by the board. Clause 47 amends the Ombudsperson for Financial Services Act to improve the administration of the Office of the Ombudsperson for Financial Services. Clause 59 amends the Securities Act to create an obligation on corporate finance advisory to keep and maintain records of debts they have raised on behalf of issuers. I now turn to some important amendments relating to corporate governance. Clause 10 amends the Companies Act to define, amongst others, independent director. Provide that the board of directors of public companies include at least 2 independent directors who are non-executive directors in line with the requirement of the Corporate Governance Code. Define conducts deemed unfairly prejudicial to shareholders and engage directors' liability for prejudicial conduct. Provide for the registrar of companies to give notice in the Gazette and by any other electronic means before the registrar restores a company to the registrar. And repeal Section 20A to reverse to the original position prior to COVID-19. Clause 20 amends the Financial Reporting Act to make the National Committee on Corporate Governance a body corporate. Clause 63, Mr. Speaker, sir, amends the definition of financial statements and provides for every statutory body specified in the first schedule of the Statutory Bodies Act, except for the Financial Services Commission, to prepare its financial statements in compliance with the international public sector accounting standards. Mr. Speaker, sir, amendments are also being made to facilitate and improve project implementation and public procurement. Thus, Clause 5 amends the Build, Operate, Transfer Projects Act to define procurement rules, make it easier for Mauritius to benefit from the expertise of foreign countries, allow for the appointment of technical advisory firms or short-term consultants in the preparation of BOT projects, and provide for a threshold value for BOT project to be referred to the Central Procurement Board, and empower the CPB to authorize, approve, and carry out pre-selection exercises for a BOT project above a prescribed amount. In the same vein, Clause 54 adds a new section in the Public-Private Partnership Act to allow the BOT projects unit and contracting authorities to appoint technical advisory firms or short-term consultants in the preparation of BOT projects. It also provides for a threshold value for contracts to be referred to the Central Procurement Board. Clause 55 repeals Section 11A of the Public Procurement Act relating to award of public-private partnership project, which is already provided for in the Build, Operate and Transfer Projects Act and the Public-Private Partnership Act. It also provides for procurement of consultancy services under emergency situations, sandbox for innovative technologies to facilitate development of proof of concept or prototypes, reservation of specific types of goods and other services for micro-enterprises, small enterprises and medium enterprises, the extension of the validity period of a bid with the agreement of the bidder concerned for such period as may be prescribed, and a public body to cancel a bidding process where the bidding document requires substantial modification and where defects or gaps in the specification have been revealed. Clause 11 amends the Construction Industry Development Board Act to review the grade designation for values of contracts that a contractor is allowed to undertake. Mr. Speaker, sir, I now turn to the amendments relating mostly to fiscal measures and tax administration. The Custom Act, Custom Tariff Act, Excise Act and VAT Act are being amended for a vast number of objectives. I will highlight some of them, starting with our tax policies. Duty-free shops and shops operating under the deferred duty and tax scheme will be allowed to sell goods on the local market without any limit on quantity, but with payment of duties and taxes for the period starting 5 June 2020 and ending on 31st December 2021. The first resolution passed in the National Assembly to increase in the rate of custom duty on import of sugar from 80% to 100% with effect from 5 June 2020 is being validated. The custom duty and VAT exemption threshold of a good imported by post or courier services is being lowered from the first 3,000 rupees of the value of the good to the first 1,000 rupees. Custom duty on equipment for use in an inland aquaculture project under the Inland Aquaculture Scheme is being exempted. Local retailing of tires will benefit from a refund of 25 rupees on each retreated tire. The second resolution passed in the National Assembly to increase the existing sugar tax on sugar-sweetened beverages from 3 cents to 6 cents per gram of sugar with effect from 5 June 2020 is being validated. In addition, the sugar tax of 6 cents per gram of sugar will be extended as from 1st November 2020 to specified locally manufactured and imported non-staple sweetened products. An excise license is being introduced at a fee of 500 rupees for importers and manufacturers of sugar-sweetened products. VAT will be charged on prescribed digital or electronic services provided by a foreign supplier. The following goods will be made zero-rated for VAT purposes instead of exempt: unprocessed agricultural and horticultural produce, live animals of a kind generally used as or yielding or producing food for human consumption other than live poultry, transport of passengers by public service vehicles, excluding contract buses for the transport of tourists and contract cars, and medical, hospital, and dental services. The following will be exempt from VAT: construction of purpose-built building, plant, and equipment for medical research and development centers, equipment for projects under the Inland Aquaculture Scheme, IT and IT-related materials and equipment for the purpose of online education for a tertiary institution ranked among the top 500 institutions worldwide, and construction of purpose-built building, plant, machinery, equipment, and materials with respect to a smart and innovative Mauritius development certificate issued by the Economic Development Board under the Smart and Innovative Mauritius Development Scheme. As regards income tax, a number of amendments are made to implement the policy changes announced in the budget. The announcements are made at clause 28 of the bill. I will highlight the main ones. The income exemption threshold are being raised with effect from 1st July 2020. These changes will range between 15,000 rupees and 80,000 rupees. A taxpayer will be allowed to claim as dependent a bedridden next of kin who is in his care and is eligible to the carer's allowance. A next of kin will include an eligible taxpayer or his spouse's father, mother, grandfather, grandmother, brother, or sister. As from the income year 2020-2021, the solidarity levy will be applied on the chargeable income plus dividends in excess of 3 million rupees of a resident citizen at the rate of 25%. The levy is capped at 10% of the sum of the net income of an individual and dividends. The specified lump sum income received by a person is excluded from the computation of the solidarity levy. The pay-as-you-earn system will apply to the solidarity levy. A company carrying on life insurance business will be taxed based on the existing system or under an alternative minimum tax, whichever is the higher. The alternative minimum tax is computed at the rate of 10% of profit attributable to shareholders, adjusted for capital gains or losses. The solidarity levy on telephony services providers, which is applicable at the rate of 5% of accounting profit and 1.5% of turnover, is being made permanent. A company which has not made profit will not be subject to the solidarity levy. A manufacturing company will benefit from 15% investment tax credit over 3 years in respect of capital expenditure incurred during the period 1st July 2020 to 30 June 2023 on new plant and machinery, excluding motor cars. The definition of manufacture is being extended to cover retreading of used tires and recycling of waste to enable such activities to benefit from incentives granted to manufacturing companies. Capital expenditure incurred on electronic, high-precision or automated manufacturing machinery or equipment on or after 1st July 2020 will be tax deductible instead of being amortized over more than 2 years. Expenditure incurred on medical research and development, if carried out in Mauritius, will be granted a double deduction. Patents and franchises costs, as well as the cost of compliance with international quality standards and norms, will also be granted a double deduction. Companies adversely affected by COVID-19 will benefit from an additional investment allowance of 100% on cost of plant and machinery, excluding motor cars acquired during the period 1st March 2020 to 30th June 2020. And 8-year income tax holiday is granted to an inland aquaculture project, a branch campus of an institution that ranks among the first 500 tertiary institutions worldwide, and a company manufacturing nutraceutical products. And the income tax liability is being deferred for companies in the tourism industry having accounting year ending during the period September 2019 to June 2020. Half of the tax will be payable in December 2020 and the remainder in June 2021. A similar facility is granted for tax payable by those companies in the calendar year 2020 under the Advance Payment Scheme. Amendments relating to property taxation and registration of deeds are at clauses 32, 46, 56, and 69. The construction of housing estate scheme is being reinstated and will operate for 2 additional years until June 2022. No registration duty and land transfer tax will be payable on the transfer of freehold bare land for the construction of a housing estate project, provided the land is transferred by 31st December 2020 and the construction is completed before 31st December 2021. No land transfer tax is payable on the sale of a residential unit under the scheme, provided it is made to a motion before 30th June 2022 and the price does not exceed 7 million rupees. A person who is a first-time buyer will benefit from registration duty exemption even if he or his spouse is or was owner or co-owner of an immovable property received by inheritance. The land area of the inherited property must be less than 20 acres. A person acquiring a social housing unit under the National Empowerment Foundation will be exempted from the payment of registration duty. A company will be exempted from payment of registration duty on the acquisition of an immovable property to be used as life science research center. Securities traded on the new venture capital market of the Stock Exchange of Mauritius will not be required to be registered with the Registrar General. As a result, the trading of these securities will not be subject to registration duty. A subsidiary of the Bank of Mauritius will be exempted from the payment of registration duty, land transfer tax, tax on transfer of leasehold, right, and fees under the Transcription and Mortgage Act. In addition, the subsidiary will be exempted from VAT and income tax. As regards tax administration, amendments are being made with a view to further leveraging the use of electronic technologies and strengthening enforcement. Clause 40 amends the Mauritius Revenue Authority Act to provide for the following. A case can be struck out if an aggrieved party or his representative is absent at 2 consecutive sittings of the Assessment Review Committee unless the absences were due to illness or other reasonable cause. An enhanced e-services platform is being set up to improve efficiency and transparency in service delivery to taxpayers. Every taxpayer will be allocated an interactive e-tax account. A master, owner, or duly authorized agent of an aircraft or ship will be able to lodge an objection at the Assessment Review Committee against a penalty imposed by the Director General for failure to submit a cargo report in respect of his aircraft or ship. Furthermore, there are amendments in other revenue laws relating to tax administration as follows. First, there will be a clear demarcation between a passenger, a crew member, and a master of an aircraft or ship for risk management purposes at customs. Second, goods imported in multiple consignments or shipments for assembly into a complete finished good to have the same tariff classification as the finished goods. Third, MRA Customs will neither suspend the clearance of imported goods nor detain goods from the local market on grounds of suspected infringement of industrial property rights. This will apply where the rights holder does not initiate any action for 2 consecutive cases of suspensions or detainment during a period of 6 months. Fourth, MRA will be empowered to regulate fees and charges leviable by a freight forwarding agent in respect of import and export of consolidated cargo. Fifth, for the purpose of VAT, the market value of goods and services supplied will be taken as the taxable value where a transaction is not at arm's length. Sixth, an application for VAT registration can be done electronically at the time of business registration and company incorporation at the Corporate and Business Registration Department. And seventh, a VAT e-licensing system will be introduced on specified businesses. 8. Electronic submission of personal income tax return and payment of tax are being made mandatory. Consequently, the due date for submission of income tax return for all taxpayers will be 15 October of each year. 9th, the time limit for MRA to effect personal income tax refunds is being reduced to 60 days. 10th, it is being made mandatory for notaries, banks, insurance companies, leasing companies, and dealers in new and imported second-hand motor vehicles to submit their deeds for registration electronically. Mr. Speaker, sir, I will now elaborate on amendments relating to pension. Clause 42 amends the National Pension Fund Act as follows. Enlarge the definition of surcharge. No contribution shall be payable in respect of the National Pension Fund by a person or by the employer of that person in respect of any period following the end of the month of August 2020. Where a person has become an insured person prior to 1st September 2020, that person shall remain an insured person on or after 1st September 2020 until he ceases to be an insured person under this Act. And benefit payable to an insured person other than the benefit payable under the Contribution Sociale Généralisée shall be calculated in accordance with this Act and on the amount of the contribution paid by him. By repealing Section 17, as it will no longer apply to those who will contribute to the CSG, the privilege in respect of contribution in favor of government to be also applicable to those who will contribute to the CSG, define the Contribution Sociale Généralisée and those who will be liable to pay the CSG as from 1st September 2020, provide for payment of CSG at the rate to be prescribed, the submission of annual return or monthly return, and the period for the payment of the CSG. The Director General of the MRA to raise assessments on employers and participants to claim the amount of CSG due, provide for the payment of penalty and interest on unpaid CSG, allow that the benefit payable in respect of CSG may be prescribed by way of regulations on such terms and conditions and to be paid out of the consolidated fund, and provide that regulations can be made for anything connected, consequential, or incidental to the CSG. Clause 49 provides in the Pension Act for officers proceeding on early voluntary retirement to be able to choose between a hypothetically one additional increment for the purpose of determining their pensionable emolument for pension purposes and a one-off payment equivalent to 2% of their annual pensionable emoluments for each completed year of pensionable service beyond 33 1/3 years of pensionable. It also reviews the role, functions, and the composition of the Public Pensions Advisory Committee. Clause 52, amend the Private Pension Scheme Act to establish a procedure for unclaimed funds to be transferred to a special fund to be set up by the FSC. Clause 64, amend the Statutory Bodies Pension Funds Act to include the Central Electricity Board so that it can create a defined contribution pension scheme for its employees who have joined service as from 1st September 2016. Clause 66, bring changes to the Sugar Industry Pension Fund Act to allow for the introduction of a defined contribution fund for employees joining service as from 1st July 2020. Clause 39 repeals the Mauritius Ex-Services Trust Fund Act. Payment of pensions to ex-servicemen and widows will be effected by the Ministry of Social Integration, Social Security, and National Solidarity. Consequential amendments have been made at Clause 74. Clause 43 amends the National Savings Fund Act to exempt a non-citizen employed by a non-citizen contractor from payment of contributions to the National Savings Fund. Delete the term recycling fee, since recycling fee is no more payable with the introduction of the PRGF in the Workers' Rights Act, and remove entitlement to the transitional unemployment benefit as it is no more linked to any scheme set up under the SEDA with the coming into force of the Workers' Rights Act. Replace the Employment Rights Act by the Workers' Rights Act. Align the provisions regarding the establishment of the Workfare Program Fund to that of the Workers' Rights Act. Provide for the Ministry of Labour to notify the Ministry of Social Security regarding payment of transition unemployment benefit, and provide in the fourth schedule for a higher rate of transition unemployment benefit payable for period 1st April 2020 to 31st March 2021, that is 90% of basic wage up to NPF ceiling for the first 6 months and 60% of basic wage to NPF ceiling for the remaining 6 months for a more comfortable income security to workers in this difficult economic period. And for the rate of the transition unemployment benefit payable for period prior to 1st April 2020 and after 31st March 2021, that is the current rate, 90% of basic wage for first 3 months, 60% from 4th to 6th month, and 30% from 7th to 12th month. Amendment is also being made at Clause 7 to the Civil Service Family Protection Scheme Act to clarify the definition of basic unreduced pension for members of the National Assembly, preserve the pension rights of all members of the National Assembly who have served prior to 1st July 2008, and not only those who were in post as at 30 June 2008, and clarified that refund of contribution to a member of the National Assembly can also be made after the age of 65 years. Clause 16 amends the Economic Development Board Act as follows: to, amongst others, define Smart and Innovative Mauritius Development Certificate and a Smart and Innovative Mauritius Development Scheme, to introduce the Youth Promotion Scheme, to authorize Economic Development Board to register smart and innovative-driven projects under the Smart and Innovative Mauritius Development Scheme, to introduce a business obstacle alert mechanism to enable an enterprise to alert the EDB of any delays faced when applying for a license, which will enable EDB to inquire about the issue, make recommendations, and publish remedial action, and in the schedule to review and harmonize the minimum investment criteria for registration of investor from 100,000 USD to 50,000 USD, remove the investment criteria for investor for innovative startups, reduce the salary criteria to 30,000 rupees for professionals in the pharmaceutical, manufacturing, and food processing sectors, and review the criteria for permanent resident permit for investors from 500,000 USD to 375,000 USD. Mr. Speaker, sir, to strengthen the legal framework for protecting and enhancing our environment, the Environment Protection Act is being amended at Clause 18 to introduce producer and importer responsibility on manufacturers, assemblers, or importers of polluting goods once their economic life has been exhausted, and allow that a person who has submitted a statement of concern further to a public notice of an EIA report may appeal against the decision of the Minister of Environment to issue an EIA. In the same vein, the Environment and Land Use Appeal Tribunal Act is being amended at Clause 17 to introduce a time frame for the Environment and Land Use Appeal Tribunal to examine whether an appeal is trivial, frivolous, or vexatious. Mr. Speaker, sir, during the COVID-19 period, a number of temporary measures have been taken that need to be revisited. In this context, Clause 23 amends the Foundations Act to repeal the temporary measures implemented during COVID-19 period. Clause 24 amends the Freeport Act to clarify that goods stored in a Freeport warehouse provided by a private Freeport developer during the COVID-19 period and such further period as may be prescribed after the COVID-19 period lapses will be cleared under normal customs procedures. Clause 68 provides for operators holding permits issued by the Tourism Authority to be exempted from payment of license fees, those having already paid the fees to be refunded, and ensures that every operator, including those for whom it is their only income-earning activity, to benefit from 2 years remission. Clause 62 amends the State Lands Act to allow for cancellation of lease as a consequence of amendments brought to the Cooperatives Act. It also provides for the increase of the rebate on rental of state lands from 50% to 100% for hotels under the Hotel Reconstruction and Renovation Scheme, and the extension of the scheme for 2 years up to 30 June 2022, and the exemption of a hotel from the payment of rental of state lands in respect of the period 1st July 2020 to 30 June 2021. Clause 30 amends the Insolvency Act to repeal the temporary measures implemented during COVID-19 period to allow any creditor to request for information from the insolvency representative and to grant power to the court to clamp down. Clause 33 amends the Limited Liability Partnership Act to reverse to the original position prior to COVID-19. Clause 34 amends the Limited Partnership Act to reverse to the original position prior to COVID-19. Mr. Speaker, sir, I will now elaborate on amendments being made to the legal framework governing the gambling sector in Mauritius. The rules are being made more stringent. To this end, Clause 25 amends the Gambling Regulatory Authority Act to specify in the definition of limited payout machine that it also includes a virtual multiplayer station or standalone roulette machine. In addition, the maximum payout will be increased from 5,000 rupees to 10,000 rupees. Restrict the definition of sporting event to a horse race or football league taking place outside Mauritius. Introduce a new definition for bet-related services and make it an offense for a person to offer bet-related services without a valid license. Empower the GRA to set up an appeal committee in such manner as may be prescribed. Make it mandatory for gaming machines and the jackpot system of any gaming machine to be tested by approved gaming laboratories. In addition, GRA inspectors are being empowered to seal the mechanical meters, game box, jackpot, and logic area of a gaming machine to prevent tampering, address repetitions and correct omissions with regard to limited payout machines in respect of compliance with technical standards as well as displacement of such machine from one side to another. Exempt the premises of a limited payout machine operator from the requirement to obtain police clearance prior to the issue of a license. Correct an omission whereby betting tax will not be applicable during a period where an operator of amusement machine is not authorized to operate, as is the case for an operator of a gaming machine and limited payout machine. Provide for a bookmaker to accept bets on football matches taking place outside Mauritius if the football matches meet the rules of fixed odds betting approved by GRA. Streamline the information to be furnished to GRA at the time of submission of an application for registration of a sweepstake retailer, pool promoter, or lottery retailer. Empower the GRA to approve new specified events for which an ad hoc license to carry out gaming activities may be granted. Allow a licensee to sponsor activities for charitable, benevolent, and social purposes. Change the period of payment of bookmaker license for conducting fixed odds betting on foreign football matches from 12-month basis to a yearly or part thereof basis. Include the rate of duties and taxes to 12% of gross stakes for the following categories: a bookmaker conducting betting on local race at race course inside and outside stand, a bookmaker conducting fixed odds bet on local horse race through remote communication, a totalisator conducting bets on horse racing, a bookmaker conducting fixed odds betting on foreign football matches, a sweepstakes organizer, and Similarly, duties and taxes are being increased for the limited payout machine operator to 12% of gross takings or 1 million rupee, whichever is higher, and for the amusement machine operator from 5,000 rupees per month to 500 rupees per machine. Clause 26 amends the Human Resource Development Act to provide that during the period 1st April 2020 to 30 June 2020, employees in the tourism sector shall pay a rate of 1% as training levy, of which 0.5% will be transferred to the National Training Fund and the remaining 0.5% to the Workfare Program Fund. And during the period 1st July 2020 to 30 June 2021, employers shall pay a rate of 1% as training levy, of which 0.5% will be transferred to the National Training Fund and the remaining 0.5% to the Workfare Program Fund. Clause 71 brings changes to the Workers' Rights Act to, amongst others, protect a worker against potential abuse regarding a shift from full-time to part-time work by limiting the period of part-time work to a maximum of 3 months, requiring the approval of the supervising officer of the Ministry of Labour, where the employer makes the request for part-time work, and providing that in case of termination, the indemnity payable to a worker be calculated on the basis of the lost remuneration earned by that worker on a full pay basis. Avoid double payment in respect of portable retirement gratuity fund with severance allowance is paid, where severance allowance is paid. Provide for the payment of remuneration where, owing to climatic conditions, an order is issued by the National Crisis Committee requiring a person to remain indoors. Extend the provision of the protective order to the ruling of the Redundancy Board. Provide for the entitlement to an end-of-year bonus under the Workers' Rights Act only to workers earning up to 100,000 rupees a month. Ensure that an employer is not allowed to reduce his workforce where he has availed himself from the financial assistance schemes. Give the worker the option to claim severance allowance to the Redundancy Board instead of going to the Industrial Court. Empower the Minister to make regulation for the financing of a social plan under the Workfare Program Fund. Extend the payment of the transition unemployment benefit to workers reckoning less than 6 months of employment ending 31st December 2020. Provide for the payment of the contribution in the Portable Retirement Gratuity Fund in respect of workers reckoning less than 12 months of employment on a pro rata basis. Reinforce the provisions against violence at work in line with International Labour Office Convention, which government intends to ratify. Provide that an employer shall commit an offence where he has failed to prevent or stop any violence at work, and pay to workers reckoning more than 6 months employment a transition unemployment benefit of 90% for the first 6 months, that is 1st April 2020 to 30 September 2020, and 60% for the next 6 months ending 31st March 2021. Clause 27 amends the Immigration Act to review the eligibility criteria for residence permit when acquiring an immovable property under the Integrated Resort Scheme, Real Estate Scheme, Invest Hotel Scheme, Property Development Scheme, or Smart City Scheme to $375,000 USD. Allow a holder of an occupation permit to bring his parents to live in Mauritius as his dependents. Review the minimum investment amount for an investor to be eligible for a permanent residence permit to $375,000 USD. Allow a non-citizen who has been a holder of an occupation permit or a residence permit as retired non-citizen for 3 years to qualify for a permanent residence permit, provided that the eligibility criteria are met. Allow non-citizens who have held an occupation permit or residence permit for at least 3 years before 1st September 2020 to be granted a permanent residence permit. Extend the validity of a permanent residence permit from 10 to 20 years. Extend the validity of an occupation permit from 3 to 10 years, and allow a holder of an occupation permit as a professional and a holder of a residence permit as a retired non-citizen to invest in any business provided that they do not manage or work in the business. Clause 44, amend the Non-Citizen Employment Restriction Act to provide that a non-citizen holder of a residence permit by virtue of an acquisition of property may take up employment without the need to apply separately for a work permit. Clause 45 amends the Non-Citizen Property Restriction Act to allow non-citizens holding a residence permit, an occupation permit, or a permanent residence permit to acquire one plot of service land for residential purposes in smart cities, empower the Prime Minister to give his covering approval and validate the acquisition of a property by a non-citizen after the transfer has been made if he is satisfied of the credentials of the non-citizens and that omission to seek prior authorization for the transaction was due to a mistake or oversight, and to provide for a fine and an imprisonment term to a non-citizen who is in breach of the provisions of the Act. Clause 8 amends the Civil Status Act to introduce checks and balances with a view to minimizing the risk of fake marriages, to enable the registrar to report suspicious marriage applications to the Commissioner of Police, and to prevent the existing discrimination and infringement of the right of citizens to get married in a place of his or her choice. Change the compulsory registration of death from within 24 hours to 48 hours as declarants or funeral undertakers face difficulties to declare the death within this short time period, and require the consent of both the father and the mother for the acknowledgement of a natural child that is being declared by the mother or the father only. Clause 9 amends the Code civil mauricien in relation to copropriété des immeubles et les ensembles immobiliers to give more flexibility in appointing a proxy for an annual general meeting of a syndic, clarify the determination of majority of votes of co-owners, and provide for the definition of an administrateur. Clause 22 amends the Food and Agricultural Research and Extension Institute Act to, amongst others, provide for officers of the Institute to have access to any other production system, including fields, farms, agro-processing enterprises, and sheltered farms to carry out research activities. Clause 36 amends the Mauritius Agricultural Marketing Act by deleting the definition of prescribed area, allowing the Agricultural Marketing Board to look into the operation of the national wholesale market, providing for the functions of the national wholesale market, and to provide for the declaration of controlled products. Clause 37 amends the Mauritius Cane Industry Authority Act to allow the Control and Arbitration Committee of the MCIA to process application for the manufacture of another type of sugar, that is, integral sugar, and a miller to deliver cane juice or any other intermediate product in sugar processing to a person engaged in the production of products other than sugar, subject to approval of the board. Clause 51 brings changes to the Plant Protection Act to provide for the setting up of a plant biosecurity technical committee, the introduction of a plant import permit to allow the importation of plant product and any regulated article, transit of consignment of plant product or other regulated articles through Freeport capable of harboring and spreading pests and diseases within our territory, identification of imported commodities to be utilized only for the purposes stipulated in the plant import permits, and penalties in case of offenses committed by an airline or cruise ship passenger. Clause 60 amends the Small Farmers Welfare Fund to broaden the definition of small planters and small farmers to enable the collection of data from small planters regarding their cultivation or breeding activities, register small farmers, and to allow officers of the fund to have access to yields farm agro-processing enterprises of small farmers in the discharge of their duties. The maximum number of poultry heads that a small poultry breeder can breed is being increased to 25,000. Clause 65 amends the Sugar Industry Efficiency Act to allow the Sugar Investment Trust to publish the notice for annual meeting in newspapers instead of sending written notice of time and place of annual general meeting to every shareholder. The clause also provides for the conversion of land upon the approval of Landscope Mauritius Limited of an extent not exceeding 10% of the land in the aggregate for residential or commercial purposes. Clause 67 amends the Sugar Insurance Fund Act to provide for the prolongation of cane harvest period in any crop year up to 30 April so as to align with the deadline for finalization of general premium, and the extension of the financial support given to small planters for crop 29-18 to a miller or a planter having total sugar accrued exceeding 60 tons. Mr. Speaker, sir, I will now highlight some other legislative amendments in the bill. Clause 12 amends the Cooperative Act to provide for retrieval of a state land leased to an agricultural cooperative society for non-compliance to the Cooperatives Act, and to empower the Registrar of Companies Societies to issue such guidelines consistent with government general policy in the context of national emergency situations, natural disasters, or force majeure. Clause 29 amends the Information and Communication Technologies Act to enlarge the scope of charging principles to also include principles that the authority may specify from time to time under such determinations, directives, and guidelines. Emphasize that a universal service means an information and communication service, including a telecommunication service determined by the authority as being a service of a defined nature and quality, of which the availability, accessibility, or affordability to end users is not adequate and has to be improved through a designated public operator. Enable the Board of the Information and Communication Technologies Authority to delegate its powers to a committee for the purpose of granting license for the operation of a radio communication service on the basis that the allocation of frequency has already been approved by the board. Fine-tune existing provisions on the licensing and regulatory functions of the ICTA. Provide for the ICTA to establish and monitor the filing of reports, including financial and costing report, by licensees in line with guidelines, directives, and determinations. Empower the ICTA to invite for application for a license and to use a competitive process for granting same. Introduce a class license whereby every person on meeting the prescribed eligibility criteria and on being registered with the authority will be allowed to carry out activities covered under that class license. Make it mandatory for an applicant to submit a complete application for a license to enable the ICTA to convey its decision within a period of 30 days, and require a prospective licensee to submit a bank guarantee and to empower the ICTA to forfeit the bank guarantee provided by licensees in case of breach of the terms or conditions of their relevant licenses. Clause 35 amends the Local Government Act to provide for mandatory online application for a building and land use permit for all construction types and sizes other than if the application is for a division of land, waive the fee for the application of the building and land use permit, waive fees payable for the issue of a BLUP for the construction of a pharmaceutical manufacturing factory, food processing plant and warehouse, and introduce a definition of a person aggrieved being an applicant whose application for an outline planning permission has been turned down by a local authority, as well as a definition for National Electronic Licensing System. Clause 41 amend the Medical Council Act to provide for the registration of a general practitioner with the Medical Council only if he has successfully undergone examination conducted by a medical examination body of international repute approved by the Minister of Health after consultation with the Medical Council, and remove the mandatory entry examination before being registered as a pre-registration trainee. Clause 50 amends the Pharmacy Act to provide for the inclusion of Indian pharmacopoeia in the definition of specified standards. Clause 48 brings changes to the Outer Islands Development Corporation Act to allow for a committee or the general manager of the corporation to enter into a transaction in respect of a capital expenditure of up to 200,000 rupees instead of 100,000 rupees. The corporation can also incur expenditure without the approval of the minister to whom responsibility for the outer islands is assigned. Clause 53 relates to changes to the Public Collections Act to allow alternative collection mechanism, including, amongst others, online collections and collections by enterprises for NGOs. Clause 57 amend the Roads Act to allow the private sector to operate and maintain footbridges along main roads and motorways and use the footbridges for controlled advertising. Clause 58 provides in the Road Traffic Act for holders of vicarious vehicles to lease their vehicles, including the carriage of goods, to eligible holders of trade licenses. Clause 31 amend the Insurance Act to allow the Insurance Industry Compensation Fund to effect payment other than compensation to victims in line with the objectives of the Hit and Run Subfund. Clause 61 bring revision to the Special Education Needs Authority Act to extend the transitional period for the registration of special education needs institutions until December 2020. Mr. Speaker, sir, I'm proposing minor technical amendments to committee stage which are being circulated in the House. I'm confident that the bill will consolidate the legal framework supporting the development of our country's economy in line with the proposal made in my budget speech. With these words, I commend the bill to the House.